If you claim you can't walk and can't go mountain climbing and can't go skiing and can't go running in your medical malpractice case because of your doctor's carelessness, do you think the defense attorney is simply going to agree and acknowledge that you can't do all those things without checking? You want to learn what this is all about? Come join me on this walk through the neighborhood as I share with you exactly what it's about. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, Daisy and I, and you can see Daisy down here, she's a beautiful little dog, going for a nice walk through the neighborhood, and I have a few moments to share this great information with you. So let's say you believe your doctor was careless, causing you significant harm and injury, right? And now you believe that as a result of your doctor's carelessness, you now are unable to do many of the activities that you were able to do before. You used to be able to play sports. You used to be able to go running, jogging, hiking, mountain climbing, and you used to do all these great sports that you love to do. And now the defense attorney, during the course of your lawsuit, asks you, hey, what is it that you're unable to do or do with difficulty? And now you rattle off a list of activities that you can no longer do or do with difficulty. So now, after explaining to him in detail exactly all the activities that you can no longer do or have trouble doing, you think that's it. You think now you've told the defense attorney everything you need to. You think he's going to take your word verbatim, meaning that everything you said is now 100% true, and now your lawsuit is going to proceed as you expect. Well, I have something to share with you. That's not exactly correct. Now that you have shared with the defense attorney in your own words exactly those activities that you are unable to do or do with difficulty, now is the time that the defense attorney is going to put you to the task. He's now going to try and confirm on his own whether or not what you have claimed is true. So you might be thinking, okay, great, let him go ahead and do that. He's not going to find anything that's inconsistent with what I've said. Well, that's exactly what should happen, right? He's going to go ahead and get your medical records from the various doctors you've treated with, and he's going to see what complaints you have made and what treatment you have received from your various doctors. All right, that's one thing. He's then going to go ahead and do a social media check. He's going to scour the internet for things that you have posted online. They're going to scour and search through your social media, including Facebook, Twitter, LinkedIn, Instagram, Snapchat, to see if there's anything on there that you have posted that is inconsistent with what you have just testified about. Now, why would they do that? Because, you know the saying, trust but verify? That's exactly what he's trying to do. He's going to try and accept what you have said as truth, but he now has to verify. And the way to do that is a couple of ways. He's not going to take your word at face value. He's going to double check through all of your medical records. Then he's going to scour the internet to see if you've done anything, posted anything to indicate that there are inconsistencies in what you have said. Then he may just go ahead and hire a private investigator to follow you to see if you are doing any activities you claimed you could not do. So maybe you're out playing basketball and have no problem whatsoever. Maybe you claim that you can't walk or walk with a limp, and now you're out playing vigorous basketball, or you're doing some other sports that you otherwise said you couldn't do. Now, there's a difference between saying, okay, I have difficulty playing this particular sport. I've tried it. Every time I try it, I have lots of pain. But still, I keep trying because I want to get better, I want to improve. And now they catch you doing that exact sport. That's different than you saying in your deposition, hey, listen, I can't play the following sports anymore, and I don't play the following sports because I have pain and I simply cannot do those things. Okay, but now they have a private investigator follow you for a few days, and they catch you on hidden video doing exactly what you claimed you could not do. So what have you just done? What you've just done is destroyed your credibility. What you've done is now shown that you may not be able to be trusted. And the defense attorney has exposed that, and he hasn't shared that with you or your lawyer yet, but he will have to, because he wants to use that against you. So don't think for a second that simply because you tell the attorney those activities you are unable to do or do with difficulty, that that's the end of it. He's going to check, he's going to double check, he's going to triple check, just to confirm and verify that what you are saying is true. So why do I share this great information with you? I share it with you because this comes up in every single personal injury and medical malpractice case in New York. Why? Because in every one of these cases, someone suffered an injury. And now the defense attorney wants to be able to confirm exactly what injury you suffered and whether or not these injuries are in fact significant, whether they are disabling, whether they are permanent. And now he's going to verify for himself. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit but are thinking of doing so, what I invite you to do if you have questions is pick up the phone and call me. You know I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.